If you're caught with a usable amount of methamphetamine in California, you could be facing criminal charges. What are the penalties for possession of methamphetamine in California? Well, good news and bad news. Today, I'm going to talk about defending a case where somebody is charged with possession of methamphetamine. This video will also deal with probably a lot of simple drug possession offenses because, like many other jurisdictions, California criminalizes what some people may call possession or drug possession or simple possession under one common statute. In this case, it is Health and Safety Code 11377. Health and Safety Code 11377 says it is a crime to possess a certain type of illegal controlled substance. And again, like many other jurisdictions, California runs a list of controlled substances that you need a prescription or some sort of more affirmative legal justification to possess them. If you just have it illicitly without a prescription or a court order or something like that, you don't have any of those reasons, it's a crime to possess the substance. And no surprise, methamphetamine is one of them. Methamphetamine, of course, has a big stigma to it as a very addictive and dangerous drug. And we don't see it being, made legal anytime soon, although it may be decriminalized in some jurisdictions, at least as a simple possessory offense. But if you're caught with a usable amount of methamphetamine in California, you could be facing criminal charges. What are the penalties for possession of methamphetamine in California? Well, simple possession of all stripes under California law can be considered for what's called diversion. You may notice in another one of our videos, we talked about Penal Code Section 1001.95. That's one way to attack a simple drug possession case. But even before that law existed, it was very common for prosecutors and courts to extend diversionary outcomes to people charged with these types of offenses, depending on what county you might be in. In short, if you're facing simple possession charges for methamphetamine, definitely talk to your lawyer whether there's a way to get the charges dismissed by way of diversion. If the DA is not willing to ask for it, file a motion for diversion under 1001.95. But what if you have certain serious or violent felony convictions on your record? Well, believe it or not, your simple possession case is not only unlikely to be diverted or less likely to be diverted, but also you could be looking at felony charges and you could be getting 16, 2 years or 3 years of state prison for something as apparently innocuous as simple drug possession. Judges may feel inclined to extend probationary sentences in these situations. And with the changing attitude towards the war on drugs, we certainly hope that, there's more leniency and treatment-based approaches to these type of offenses, or maybe decriminalization altogether. However, for now, the state of the law is if you have prior serious or violent felony or strike convictions and you suddenly find yourself in possession of methamphetamine and caught with it, you could be facing felony penalties, even something as serious as state prison, as strange as that sounds. If you know anybody who is facing charges of simple possession under Health and Safety Code 11377 or any kind of related methamphetamine or other drug charges, please contact us immediately for a free consultation. I'm sure we can help.